Hello everyone, welcome to IPM IAS Academy's Swift Revision Sessions. So in this Swift Revision session, we are first choosing Indian Polity as a subject. So Indian Polity, as you know, it is one of the most demanding subjects in civil service examination. Even if you are looking at the prelims or looking at the mains, you can see that it has its own importance in the examination. And soon after finishing the examination, once you are becoming a civil service officer also, the importance of Indian polity is really big. Because, like basically when you are getting into this administration, you need to know about the rules and regulations of this country, the constitution of this country, the governance aspects of this country, the administrative elements of this country. Everything is mandatory for you to understand, right? So all these things you will be able to study from Indian polity. So that is the importance of this particular subject. And today we are going to go through a quick revision. Quick revision, why we are actually doing this. Basically, for the last 1 year or 2 years, you may be studying for civil service examination. And most of the time, we may feel like, okay, I didn't study properly well. Okay, I'm not able to recollect the information properly. So these things will come to your mind. No, these confusions will be there in your mind. So in order to sort out that confusion, we are actually giving you this swift revision. So when you are going through this revision, no, you will be able to recollect the information that you have already studied. And you will feel more confident once you are finishing this particular revision session. So please make sure that you watch this revision session 1, 2, 3 times, as many number of times possible for you based on your need. So if anybody wants to join any of our courses, you will get the deeper understanding regarding the subjects, and you will get the detailed videos of all the subjects in the courses. So before moving into the subject, let me introduce myself. I'm Gauthaman Mohan. I'm the academic head and founder of IPM IAS Academy. And IPM IAS Academy, as you all know, it is one of the leading IAS academies which is focusing on the online method. And we have an application, IPM IAS application. You will get all the recorded videos in the IPM IAS application. Basically, it provides the concepts and the contents for all the subjects, all the general studies subjects, and it is a complete solution for the civil services training in India. And it is one of the most affordable programs in India also. I hope my screen is visible for all of you. So let us start our session. So Indian polity, basically it's a swift revision, very quick revision for Indian polity. So please be there because we are going through almost all the concepts in Indian polity in a very quick manner. Okay, so please be there with me. Okay, so before moving into the classes, let me introduce our programs. We have a 1-year IAS program, 2-year IAS program. We have foundation courses. We have current affairs program. We have each subject specific programs are there, like for history, for geography, for polity, for economy. For all these subjects, separate programs are there in IPM IAS application, and we have CSAT classes also available in the application. And more than all these things, we would like to introduce this particular course for you. So this is IAS Dream Experience Program. So it's one of the most important initiative in India also. Why? Because we are giving you an experience about how to prepare for the examination. When as beginners, when you are actually planning to join for any of the programs, you are confused where to join, what to study, all those confusion will be there. So in order to sort out that confusion, we are offering this program, IAS Dream Experience Program. And this program is available at 3,000 rupees for 3 months. Okay, so the total cost of this program is 3,000 only, and you will get its access for 3 months. And access in the sense, you will get all the contents. Okay, the entire contents for civil service examination, you will get it for 3 months. So basically, you can understand how to prepare for the examination, what is the mindset needed for the examination, what are the subjects you need to study, and how to allocate time for that, what are the contents, and all these contents are there in topic specific recorded videos. Small videos are available, so recorded videos, so that it covers the entire syllabus also, so you can plan your journey in a very well organized manner. And once by finishing this particular program in 3 months, if you are really happy with the program that we are offering, you can be a part of any of our programs, either 1-year program or 2-year program. So this is a wonderful initiative from our side, and we would like to give that experience to all of you. You should not be confused about how to go for this training process. And one more thing is, like, before making a huge investment, you can actually experience it, and you can see how And one more thing is like before making a huge investment, you can experience the whole program and you can make the investment according to that. Okay, if you are feeling like, okay, I'm confident about moving further, you can definitely invest for this particular program. Okay, so this is the importance of this program. Please do understand and try to be a part of this program. All the links for our courses will be available in the description. So please do go and check the programs. Or else you can also check the programs in www.ipmiasacademy.com. So coming to the first part of the Indian polity session, and basically we are not going into the details of the historical aspects that we will be giving you as a separate video itself, and we will be starting from preamble itself. Okay, the preamble of the Indian Constitution. Let us try to understand what is this preamble all about. As you understand it properly, it is a preface to the Constitution. Okay, it's basically a preface to the Constitution. And this is what the preamble says. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Very important points, right? Socialist, secular, democratic republic. Then there is justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all, and fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Very important concepts. It talks about the philosophy, it talks about the nature, it talks about the features of the Indian Constitution. And basically, before moving into the deeper aspects of the Constitution itself, you will understand what is this Constitution, what is the philosophy of this Constitution just by going through the preamble itself. And in the last part, you can see that in our Constituent Assembly on this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. And this particular day we observe as the Constitution Day, November 26, 1949. Okay, every year, November 26, we observe the Constitution Day. Okay, it was actually adopted in the Constituent Assembly. You know that Constituent Assembly was formed for the purpose of providing or creating a constitution for our country, and the Constituent Assembly itself has adopted it on 26 November 1949. And don't confuse it with the commencement day. The commencement day is our Republic Day, that is 26 January 1950. Okay, so this is the preamble of our Constitution. And once you are moving into the deeper aspects of the preamble, you can see that it serves as a preface to the Constitution. Very, very important. It's a preface to the Constitution. It set the principle, purpose, and philosophy of the Constitution. You can understand that, no? From the wordings that we are actually using in the preamble itself, you can understand it shows the principle, it shows the purpose, and it also talks about the philosophy of the Constitution. The preamble to the Constitution is aimed to embody the fundamental values and the philosophy on which the Constitution is based. Basically, the fundamental values and ethos of our Constitution you will be able to find in the preamble itself. And in the words of N.A. Palkhiwala, the famous jurist and constitutional expert, he mentioned that preamble of the Constitution is the identity card of the Constitution. Basically, it's an identity card of the Constitution. And the Constituent Assembly of India adopted the objectives resolution introduced by Jawaharlal Nehru. So basically, when the Constituent Assembly was formed, they are also clueless how to move further, right? So in order to give an objective for this entire Constituent Assembly, how the Constitution should be, the objectives of the Constituent Assembly was actually placed by the Jawaharlal Nehru, that is known as objective resolution, and almost every aspect of objective resolution is taken into a preamble also. Okay, certain changes are there, but apart from that, almost every aspect of the objective resolution can be seen in the preamble of our Indian Constitution. And the preamble put forth the philosophy and fundamental values of the Constitution, as well as the ideals and aspirations of the people. Very important. The ideals and aspirations of the people are also mentioned or also discussed in the preamble. It is not only talking about the philosophy or the principle, it also talks about the ideals and aspirations of the people. And now, what are the different elements of this preamble? The preamble reveals the source of authority of the constitution. One part, the source of authority, who give the authority for this constitution. Then the nature of the Indian state is discussed in that. The objectives of the constitution is discussed in that, and also the date of adoption of the constitution is discussed in that. So if you look at the preamble, you can actually divide it into four important parts. One talks about the source of authority, one talks about the nature of the constitution of the Indian state and the objectives of the constitution, and also the date in which it was adopted. So these are the things you will be able to understand from the preamble itself. Now, coming to the source of authority, what do you mean by that? Okay, so the source of authority talks, it's a sovereign constituent assembly. Okay, it's a sovereign constituent assembly representing all Indians, framed, adopted, and enacted the Indian Constitution. So, based on the available options during that time, they tried to include everybody from the society, tried to include, but it was not a complete representation. You cannot say that the whole Indians were completely represented in the Constituent Assembly, but based on the options available during that time and based on the administrative procedures during that time, they tried to include that. Okay. Now the Constitution derives its authority from whom? It derives its authority from the people of India. Very important. So the source of authority of this constitution is actually the people of India. Now the nature of the Indian state, very important. The Constitution of India defined Indian state as sovereign, okay, sovereign, socialist, secular, democratic republic. Very important. Sovereign, socialist, secular, democratic republic. And now when you're looking at it, you can see five important nature you will be able to see. But during the commencement of the constitution, there were only three things. Okay, well, what were they? They were sovereign, democratic republic. Later, socialist and secular were added to our constitution with the 42nd Amendment Act of 1976. The socialist and secular was added to our constitution. Please understand this very, very properly. Now, what do you mean by sovereign? Sovereign means the supreme authority. So basically, India is free to conduct her internal and external affairs independently, and it is not a protectorate affiliated to any other state. It's highly independent in nature, and India can take their own decisions. And when you're talking about sovereignty, you can also talk about the external sovereignty and internal sovereignty. Inside the country, what all things are happening, and outside the country, how the decisions are being taken. So both the things can be applicable in the sovereign aspect. That is the first point. The second point is socialist. Okay, India would seek to establish socialist society based on the democratic ideals, and you can see that the secure social, political, and economic justice was also an important concept or important feature of the socialist principle of the Indian Constitution. Okay, basically securing the social, political, and economic justice, establishing that in the society becomes a part of the Indian Constitution. Now coming to secularism. What do you mean by secularism? The Indian Constitution adopted the ideals of positive secularism, treating all religions with equal respect and dignity. Okay, all religions are considered to be equal. Okay, everybody has equal opportunity to propagate their religion in the country. So that is what you can understand from this secularist ideal. And one more thing is, like, India does not have an official religion. Okay, we do not accept or we do not adopt an official religion. Every religion is equal. Now, India's uniqueness is in its unity in diversity. So, very important terminology, unity in diversity. You know that India is diverse in various areas. Okay, if you look at the religion, if you look at language, if you look at the food habits, if you look at dressings, if you look at the dialects of every area, you can see that India has its own diversity. But in that diversity also we remain united. So that is the unity in diversity. The sense of that Indian, that sense of that nationality is always there in everybody's mind. Now the third one, you can see that, fourth one, you can see that it's democratic. So India has adopted a representative and responsible parliamentary democracy, very important, responsible parliamentary democracy, in which supreme power is possessed by the people, very important. Supreme power is possessed by the people. Why? Because you can see that when you're looking at the election process in our country or the government functioning in our country, it is for the people, by the people, and of the people. Okay, of the people, for the people, and by the people. So everything is actually decided by the people only in this country. Okay, who should be the prime minister of this country? People decide that, right? So every aspects of governance are actually decided by the people. That is the reason why we are considered it as a democratic state. And universal adult franchise, periodic elections, rule of law, independence of judiciary, prohibition of discrimination on certain grounds are the salient features of the democratic character of Indian polity. Okay, universal adult franchise, in which you can see that those who are attained the age of 18, they will be able to vote for the elections. Then periodic elections are actually conducted every 5 years. You can see that elections are conducted in our country, and there is something called as the rule of law. All are equal before the eyes of law. That is the concept of rule of law. And there is no arbitrary rule existing in our country, and it is everything is based on the written laws in this country. And independence of judiciary. Judiciary is free to take its own decisions. It is not dependent on anyone, anything like the other organs of the government, like legislature and executive. The judiciary is not dependent on those things. Then prohibition of discrimination on certain grounds, very important. On certain grounds, you can see that there is prohibition of discrimination, because equality should be, established in the society. Inequality should not be entertained in the society. That is the main idea of our democratic form of government. Now, the last one is the republic. The word republic means the sovereign head of the state is elected indirectly for a fixed tenure. So, the sovereign head of the state is the president. You know that the president is actually indirectly elected. It is not a direct election process. It's an indirect election process. Why we are saying it as an indirect election process? Because all the people are not becoming a part of this election process. All the people means the people who have attained the age of 18 plus, they get this universal adult franchise or the voting right. No, but they are not a part of the presidential election. So the presidential election is actually conducted with the help of the electoral college. But in the case of other countries like the UK, there is the monarchy is existing, or a constitutional monarchy is existing. And you can see that India is neither a constitutional monarch nor a state with office of its sovereign head reserved for special class of individuals through nominations. There is no nomination. Proper election is conducted for the presidential post, and it is not a hereditary post. Hereditary means it's a monarchical form of government, right? So it is not a hereditary post. It's the elections are conducted, but that election is indirect in nature. So that is republic. Okay, that's the idea of republic, or the feature of republic in our country. Now, coming to the objectives of the constitution, you can see that justice, liberty, equality, and fraternity for all the citizens. Okay, you can see that. So, social, economic, and political justice. These justice should be, protected. Social justice implies equal treatment of all citizens without any distinction based on caste, color, religion, race, sex, and so on. It involves absence of privileges and also for the development of backward classes. Okay, that is very important. Then economic justice means it denotes the non-discrimination based on economic factors, eliminating the glaring inequalities in wealth, income, and property. That is economic inequality, economic justice. Okay, there should not be economic inequality in the country. Then combination of social and economic justice is distributive justice. Then political justice means equal access to political rights, political offices, and voice in the governance. Okay, I'm just going fast because I'm pretty sure that you know these concepts. I'm just reinstating those concepts for you. I'm just giving that revision part of it, taking care of that revision part of it. Okay, then. So basically, political justice means in political aspects, how the rights are actually enjoyed by the citizens here, then their access to political offices and their voice in the governance process, all these indicates the political justice. And this idea of justice, we have actually taken it from the Russian Revolution, happened in 1917. Russian Revolution 1917. Now, the other important objectives, you can see that liberty of thought, expression, belief, faith, and worship. Liberty of thought, okay, you can think, then expression, you can express your things, then you have belief, you have faith, and you have worship. In all these areas, you have that freedom. The absence of restraints on the activities of individuals and providing opportunities for their development, very important. The liberty has to be enjoyed within the limitations mentioned in the Constitution. within the limitations mentioned in the constitution, you should be enjoying your liberty. The ideals of liberty, equality, and fraternity was taken from French Revolution. Okay, the French Revolution happened in 1789. Okay, 1789. So there's a mistake here. So it was happened in the year 1789. Now, equality of status and of opportunities. You can see that equality denotes the absence of special privileges to any section in the state and also to provide opportunity for their development. So certain articles in our constitution itself proves that there is equality in the country, especially when you're looking at the fundamental rights. There is a particular section of the fundamental right is mainly dealing with equality only. Article 14 to Article 18 of the Constitution deals with equality. Article 325 mainly talks about no person to be declared ineligible for inclusion in the electoral rolls on the basis of religion, race, caste, sex, etc. Then Article 326 talks about election based on universal adult franchise. What is important eligibility there? You should have attained the age of 18. That is the eligibility criteria. Now coming to the fraternity part, the fraternity among individuals. Basically, the Constitution promotes that sense of brotherhood. Fraternity means that idea of brotherhood. The state adopted the system of single citizenship to ensure fraternity. You know that in India, we are not having any kind of dual citizenship, multiple citizenship and all. So we have only one citizenship, that is Indian citizenship. Okay. So why we are actually doing that? Why we are actually choosing that? It's because that shows our fraternity, that shows our brotherhood. And Article 51A of the Constitution says that it is a duty of every citizen to promote harmony and common brotherhood amongst all the people. So amongst all the people, that harmony and common brotherhood should be there. Now coming to the unity and integrity of the nation. So this unity and integrity word was also inserted to our constitution through an amendment, that is 42nd amendment, happened in the year 1976. Okay, then the original preamble was unity of the nation only, but with the amendment, you could see that the word integrity was added to it. It includes the territorial and the psychological dimensions of the national integration. So not only the territorial part or the boundary part, it also talks about the psychological aspects of the dimensions of the national integration. Article 1, it says that India as a union of states. India as a union of states. India, that is Bharat, shall be a union of states. That is what is there in Article 1. And it aims to overcome challenges like regionalism, communalism, casteism, linguism, and so on. So these are all separate tendencies, right? Separatist movements, and all these separatist tendencies should be avoided. That is the reason why we are having that idea of unity and integrity. The date of adoption. The date of adoption is very important. Okay, when you're looking at the date of adoption, you can see that the Constitution was ratified by the members of the Constituent Assembly on 26th November 1949, and that day is considered to be the Constitution Day also. November 26th is considered to be the Constitution Day also. So it was actually enacted and adopted by the Constituent Assembly, but it was not open for everybody in the country. It was open to everyone in the country during the commencement day only, and that commencement day was 26th January 1950. Okay. Now, we would like to introduce the book Get Set Go for IAS, a blueprint for effective UPSC preparation, and it is available in the Amazon as ebook. You can actually purchase the book. And if you have any doubts regarding how to prepare for this examination and all those doubts, all the effective tips, all the effective strategies, everything is actually covered in that particular book, and you can just go and purchase that in the Amazon. Then now coming to the features of the Indian Constitution, very important aspect, the salient features of the Indian Constitution. Okay, you should understand about it. Salient features, first one is the lengthiest written constitution in the world. You can see that Indian Constitution, because it took almost around 3 years to complete the entire constitution drafting. So you could see that it has become the lengthiest written constitution in the world. So that many articles and that many parts, schedules were there in the constitution. And you could see that we were not simply sitting there and trying to write whatever comes to our mind. No, that was not the thing we were doing. What we were doing was we were actually referring certain things, okay, certain other countries' documents, other countries' constitutions, and we have adopted certain things from other countries also. So you could see that we have adopted certain aspects from USA, USSR, everywhere. Like you can see that the fundamental rights came from USA, the fundamental duties we have adopted from USSR, the process for amendment we adopted from the South America, the DPSP we have adopted it from the Irish Constitution. So all these were actually adopted from various parts of the world, right? So certain things we have actually made for our people also. So they have actually drafted that in our country. So there were aspects from different parts of the world. That is what is meant by drawn from various sources. Then it's a blend of rigidity and flexibility. That is very important to understand. Blend of rigidity and flexibility. So basically, it's a mix of rigidity and flexibility. So why it is rigid and why it is flexible? Rigid means certain parts of our constitution is easy to change. That is flexibility. And certain parts of the constitution or certain aspects of the constitution is very difficult to change. And that is rigidity. So that is the blend. So that is the reason why we are having more than 100 amendments in our constitution. Basically, because we are a mix of this rigidity and flexibility. But if it was rigid, then we wouldn't be having this many number of amendments in the constitution. So amendment is the one that is actually deciding whether it is rigid or flexible. Then federal system with a unitary bias. Okay, so we are having a quasi-federal system. Basically, you can see that when you're looking at the Indian system, there is a central government and there is a state government, and the authority, the power is actually there in the hands of the union government. So that is the way they have actually put it in these terms. Federal system with a unitary bias. The inclination is more towards the unitary feature. Now, the parliamentary form of government, you know that it's a synthesis of parliamentary sovereignty and judicial supremacy. So that is also a very important concept. You know how it works. The parliament has the authority to make laws on any aspects, and they also have the authority to amend the constitution. But whenever they are making laws or whenever they are amending the constitution, if it is going against the core values of the constitution, if it is going against the fundamental nature of our constitution, then the judiciary can interfere that. That is known as judicial review. The judiciary has the authority to review the law which is made by the parliament. So that is the synthesis of parliamentary sovereignty and judicial supremacy. Now we have an integrated and independent judiciary. You know that our judicial system structure is integrated in nature. We have a Supreme Court, we have a High Court, and we have subordinate courts. And then on the other hand, you can also see that we are not depending on any other bodies, especially legislature and executive does not have any role or any influence over the judiciary in our country. It is independent in nature. So the justice system should be independent in nature. Now we have fundamental rights. Every citizen in this country have their own rights, okay, to lead a dignified life, and all those fundamental rights are mentioned in part 3 of the Indian Constitution. Then there is something called as directive principles of state policy, otherwise known as DPSP. So what do you mean by DPSP? So basically these are certain directions, directive principles given to the state. So whenever and wherever it is necessary for the state to make a law, they can always look at this DPSP, because DPSP contains the novel features of the Indian Constitution. It contains the best features of the Indian Constitution, the best ideas of the Indian Constitution. So you can actually take one of those ideas and then make it as a law. So that is the reason why it is named as Directive Principles of State Policy. Then there is something called as fundamental duties. We have already mentioned that the people of this country enjoy something called as rights. And when you are enjoying rights, you should also be aware about the duties that you have, the obligation that you have towards this society. Then the secularism, we already discussed about the secularism in the preamble part. Then universal adult franchise we discussed. Then single citizenship we discussed. Then there are certain independent bodies. So in order to make sure that the administration is going smoothly, the welfare of the people are actually taken care of. In order to do that, we have certain independent bodies. One is the UPSC, the Union Public Service Commission we have. Then the Finance Commission we have. Then we have the Attorney General. So these are all independent bodies functioning under the in our country, and it is actually mentioned in the Constitution also. Then the emergency provisions. You know that when the country is going through a crisis, then it is the authority of the president to establish emergency in our country. And there are three types of emergency existing in our country. One is the national emergency, then state emergency, and financial emergency. Then we have a three-tier form of government. Okay, the government is having three type of union government, state government, then the local self-government is also available. And once you're looking at the local self-government also, there is a three-tier division you will be able to see. Then there are cooperative societies for the welfare of the people. Okay, so they can have their own associations or cooperatives to for the better well-being of that particular area, that particular people, and that particular group. Okay, so these are some of the salient features of the Indian Constitution, some of the salient features of the Indian Constitution. And once you're understanding the preamble and the salient features of the Indian Constitution in a very well manner, no, then almost the entire Constitution is in your hands. Okay, the idea, the conceptual understanding of the Constitution will be there in your mind. Okay. Now coming to the part one of the Indian Constitution, that is union and territory. I'm going a little bit faster. Okay, I'm not going into each and every detail of the slides. Okay, so that you will gain it fast. Okay, you will get the knowledge in a faster manner. So part one, union and territory. So part one of the Indian Constitution talks about the union and territory. So let's see what is that. So the present Indian state consists of 38 states and 8 union territories. You know that. Then both are different in terms of governance, structure, and functions. Okay, so we have a union government and we have other state governments and we have union territories also. Then in the union territories, the central government appoints a lieutenant governor, and in the case of Puducherry and Delhi, they have an elected legislature and government. So you know, like the union government has their own form of government. There is a parliament and there is a Prime Minister and Council of Ministers, and the states also you can see that there is a Chief Minister, there is a Governor, there is a Council of Ministers you can see, and same like that in the Union territories, the administrative control is mainly dealt by the Union government, Union territories case. Okay, but when you look at the Puducherry and Delhi, you can see that they have a legislature. Okay, their election is going on in that region, and they have a separate legislature also. So these are the states and their capitals in our country. So you can just pause here and then just go through it. You can just go through it. Now coming to the union territories and its capitals, we'll be able to see that here also. You can pause and you can just go through it. Now, what is the difference between a state and a union territory? Large in territory when you're looking at the state, but in the case of union territory, it's small, and there is a separate government in the state, but union territories under the central government. Then legislative and executive powers are distributed, and here the legislative and executive powers are under the central government. Then here the chief minister is elected by the people, but here administrator is appointed by the president. And then the states have share in federal system. The union territory is directly administered by the central government. So we cannot say that they have a share in that, because already it is actually under the control of the union territory, union government only. Now, how the evolution of the states and union territories happened. So basically, when we were getting independence, you could see that there were British Indian provinces and princely states. The British Indian provinces were mainly coming under the British government. The places which were completely under the control of the British government can be termed as the British Indian provinces. And when it coming to the princely states, you know that the native princes were mainly the leaders or the rulers of that particular territory. And Indian Independence Act created two dominions. One is the India and one is Pakistan. And out of 552 princely states, 3 did not join the Indian Union. Very important. Out of 552, 3 did not join. And what were they? Hyderabad, Junagadh, and Kashmir. But later it were actually came into Indian Union only. And Hyderabad through police action, Junagadh through referendum. So referendum is a process in which a direct vote by the electorate on a proposal, law, or political issue. So people are mainly participating in that process and they will be deciding. And through that, Junagadh become a part of India, and then Kashmir through an instrument of accession. It's a legal document signed between the government of India and the king of Kashmir during that time. And through that accession, they become a part of India. Okay. Now, in 1947, to enable each of the rulers of the princely states under British paramountcy to join one of the new dominions of India or Pakistan created by the partition of India. Basically, what is this instrument of accession? So that is what is mentioned here. So through that instrument of accession only, Kashmir will become a part of India. And there is a history, there is a long history for that. I'm not going into the details of it. Now, what was the condition of the states during that time. So there were four types of classified into four types. One was part A states, part B states, okay, part A, part B, and part C and part D. Okay, part A, part B, part C, and part D. So what were part A state composed of? They were 9 erstwhile governors provinces of British India. So the big territories of the presidencies during that time were part of it, like Bombay, Madras, Assam, Uttar Pradesh, or Punjab, then Odisha, or West Bengal, all were part of this part A states. When it coming to the part B, you could see that the erstwhile princely states and with legislatures, certain princely states were having legislatures and they were coming under the part B. They were Patiala and East Punjab, Hyderabad, Jammu and Kashmir, Vindhya Pradesh, Travancore, Cochin, Madhya Bharat, all those become part of the part B. Then part C composed of the chief commissioners provinces of British India and some princely states, okay, like Ajmer, Bhopal, Bilaspur, Delhi, Himachal Pradesh, Kutch, Manipur, Tripura, etc. Then part D states were the Andaman and Nicobar Islands, which was actually administered by the Lieutenant Governor appointed by the central government. So that was the original composition during that time, the classification during that time. Now, how it actually evolved as a state. So there were demands from different parts of the country regarding the formation of states, and they have actually formulated one commission called as Dhar Commission. S.K. Dhar was the chairman of that commission, and with that commission, they have came to a conclusion that the reorganization of the state should be based on administrative convenience, not based on linguistic convenience. Okay. So that was a failure because the people were not ready to accept that. And then comes the next commission, that was the JVP commission. JVP means J for Jawaharlal Nehru, B for Vallabhbhai Patel, and P for Pattabhi Sitaramayya. And they have also rejected the idea of states based on language. Okay, so the two commissions, they rejected the idea of state based on language. So during that time, what happened was in Andhra Pradesh, Poti Sriramalu, he was on a hunger strike to separate or to create Andhra. Okay, hunger strike to create Andhra. And what happened was in that hunger strike, on 56th day, he was actually died. Okay, so in the year 1953, Andhra was created, separated the Telugu-speaking areas from Madras state. This initiative was taken due to the death of Poti Sriramalu after 56-day hunger strike for the creation of Andhra Pradesh. So he was the person behind the creation of Andhra Pradesh, and that actually became a spark for other territories to claim for their power, to claim for their rights. That is, they should also get a state based on their language. So then they have actually formulated one commission called as the Fazal Ali Commission in the year 1953. You could see that, and they have accepted the linguistic basis of reorganization. That is, the language as a basis for reorganization. And who are the members of this particular commission? You could see that Fazal Ali was there, K.M. Panikkar was there, and H.N. Kunzulu was there. Okay, they were the members of that particular commission. And like that, the reorganization happened, and one factors which they need to be taken into consideration while they are reorganizing the state. One is preservation and strengthening the unity and security of the country. So basically, it should not compromise the unity and security of the country. It should be preserving and strengthening the unity, right? The second one is the linguistic and cultural homogeneity should be taken care of. Then financial, economic, and administrative considerations should be taken care of, and planning and promotion of the welfare of the people should be taken care of. All these four factors should be taken into consideration when you are actually doing the reorganization. And by the States Reorganization Act 1956, 7th Constitutional Amendment Act, that is 14 states, 6 union territories were created on November 1st, 1956. 14 states and 6 union territories. Now, what are those 14 states and 6 union territories? You can see it here. Okay, just pause for a moment and then write it down. Just try to recollect this information. Okay, Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, and on the other hand, Union Territories, Andaman Nicobar, Delhi, Himachal Pradesh, Manipur, Tripura, etc. So when you're looking at it, you will get a confusion. Okay, surely you will get a confusion because some of these Union Territories are actually states now, and some of these states are actually Union Territories now. So this confusion will definitely be there, and that will be solved when you're actually looking at this particular area. That is how each state was actually formed. This is a date-wise, year-wise, classification of the formation of various states. Here also you can pause for a moment and then you can just go through it. Pause it and then go through it. Now coming to Article 1 of the Indian Constitution. Basically, what is Article 1 of the Indian Constitution? So when the Indian Constitution was actually formed, you could see that there were 22 parts, 8 schedules, and 395 articles. Okay, 395 articles, 22 parts, and 8 schedules were there. But later it was all changed. Okay, because of various amendments, you could see that now we are having 448 plus articles are there, and then we have 25 parts and 12 schedules. Okay, so this is the change happened. Now, what is Article 1? The Article 1 mainly talks about India, that is, Bharat shall be a union of states. And very clearly, we have mentioned that we are not a federation of states, we are a union of states. So why it is not a federation of states? Always the federation of states, they have the authority, the states has the authority to secede from the federation. But in the Indian Union, the states do not have any authority to secede from the federation, or secede from the union. Okay, so according to Dr. B.R. Ambedkar, we could see that the Union of States was used because of 2 reasons. One, Indian Federation is not a result of an agreement like American Federation. So American Federation was formed based on an agreement. All the states in America, they have actually becoming a part of that federation through an agreement. And they have the right to secede from that also. But here in our union is indestructible. Okay, so that they cannot go out of the union. Now, the Indian territory composed of the state territories, the union territories specified in the first schedule, and the territories later acquired. Okay, so during that time, it was the number of territories were less, but later certain territories were added to our place or our country. Okay, the first schedule of the Indian Constitution deals with the names of the states and union territories and their territorial extent. Okay. Now, in what all ways you can actually take one territory into our control? So you can actually, it can be a secession, then it can be an occupation, or it can be a conquest or subjugation. So you could see that Daman and Diu, Puducherry, Dadra, Nagar Haveli, Goa, Sikkim were later acquired by India. It was not part of the original India in the year 1915. It was later acquired to be a part of India. Then Article 2. So Article 1, it was India, that is, Bharat shall be a union of states. Article 2 mainly talks about the admission or establishment of new states. How new states were admitted to our country. It is not talking about the reorganization happening inside the state. It is only talking about new admission. Okay, these are foreign territories, but now they are actually becoming a part of India. Okay, that is Article 2. Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fits. So basically, you need to understand that in all these areas, who is having that authority to make decisions? It is a parliament which is having the authority to make decisions. And the Article 2 of the Constitution empowers Parliament of India with exclusive legislative powers to admit foreign territories. Exclusive legislative powers. Then the Parliament of India can enact laws to admit foreign territories and establish new states. The state legislature cannot enact laws to admit foreign territories and establish new states. So this can be a tricky question in the examination. So they may say that the state legislature has the authority. No, state legislature does not have a role in the admission of foreign territories to India. Goa, Daman and Diu, Pondicherry, Sikkim were later incorporated to the Indian territory. Okay, then you could see that Sikkim also was becoming a part of India on a later date. Then what is Article 3? Article 3 talks about the formation of new states, alteration of areas, boundaries of or names of existing states. So here we are mainly talking about the reorganization of the states, because here we are going to talk about changes that are happening inside the territory of the country. Which means we are not inviting a foreign territory to our country. We are only making changes to the already existing territory of this country. Okay, so what is meant by this Article 3? With this article, the Parliament may by law form a new state by separation of a territory from any state, or by uniting 2 or more states. Okay, a state can be separated, 2 states can be joined together, and parts of states, or by uniting any territory to a part of any state. So one territory can be this can be another territory, this can be becoming part of it. So like that, in various ways inside our country, the states can be reorganized. They can increase the state of any area of any state. They can diminish the area of any state. They can alter the boundaries of any state, and they can alter the name of any state. You could see that certain names of the states were changed. Okay, now it is not the old name that you will be seeing. For example, it was Orissa in years before, and now it is Odisha. Okay, it is Odisha now. Okay, so like that, new states formed, Telangana and Andhra. It was only Andhra Pradesh, but now you can see that it is Telangana. Bifurcation of the state happened, and the two union territories were formed recently, Ladakh and Jammu and Kashmir. Okay, it was Jammu and Kashmir was a state then, but now it is a union territory. So all these things are actually possible inside the country with this article only. So this article is giving that authority to make all these changes. Then this particular term, this particular quote is very important. That is, India is an indestructible union of destructible states. Indestructible union, which means the union cannot be destructed. But inside, you can make any changes. Regarding the states, you can make changes. You can actually change the state. You can change its name. You can actually bifurcate the state. All these things are possible. But you are not going to touch the entire union. Union cannot be shaped. Cannot be, changed or destructed. Okay, only the states you can actually destruct and form a new one. Okay, so that is, India is an indestructible union of destructible states. You can actually explain it in various ways. You can interpret that in different ways. Okay, it is possible. Then Article 4. So whatever changes that are happening in these the first part of the Constitution, no. So we cannot consider it as especially Article 3 and all, whatever changes are happening in the organization part, we won't be able to consider it as an amendment of the Constitution. That is what is mentioned in this one. Okay. But when we are talking about the admission of the states, which a new state is actually formed, or some changes are happening to our Constitution, so all those things will be considered as an amendment. So amendments are of three kinds, you can say, basically two kinds, but one is simple majority. So all these things, changes like the third Article 3 is actually happening on the basis of the simple majority one. But on the other hand, you could see that certain changes which needs more more permissions or more consent, it has to go through two-third majority. And another important one is two-third majority plus ratification of half of the states. The legislative procedure, very important to understand this legislative procedure, how the states are actually formed. So the Union Council of Ministers, consults with all stakeholders to prepare a draft for reorganization of the states with proposals on area, boundaries, name of the state, etc. So basically, Union Council of Ministers consults with all stakeholders, whoever is included in that. Now, the Union Council of Ministers introduces the state reorganization bill in either house of the parliament with prior recommendation of the president. So, a president's prior recommendation is needed here. The state reorganization bill shall not be deemed to be considered as a constitutional amendment under Article 368. Very important. So, a state reorganization bill is not a constitutional amendment under Article 368. The president refers the state reorganization bills to the respective state legislatures. Okay, the state legislature needs to express their views on the recommendation of the bill within the period specified in the reference or so allowed by the president. Okay, so basically, if they are trying to bifurcate Andhra Pradesh, then they have to inform Andhra Pradesh, and Andhra Pradesh can actually come up with their own suggestions to the president based on the time period fixed by the bill or by the president. And in case of union territory, no reference needed to be made because union territory is already under the control of the union government only. Then the parliament can itself take any decision as it deems fit. Okay, so the president is not required to submit such a reorganization bill to the union parliament with assent of the state legislature. So even if they are getting some, protest from the state legislature also, it is not mandatory that the president has to submit that bill again to the union government. No, the president can take action. Then the parliament can enact the bill. So the parliament enacts the state reorganization bill, and president certifies the state reorganization bill to an. So this is the process. Okay, it's a process of it's a legislative process for state reorganization bill in our country. So you can just pause for a moment and you can just read it, you will understand it clearly. Part 2 of the constitution mainly deals with citizenship. Okay, citizenship. The first part we were discussing about the state, the land area. Now we are moving on to the citizens, those who are living in this particular territory. Okay, so that is citizens. So who is a citizen? What is the advantage of being a citizen? Everything is actually coming under this particular part. Then the population of the country is always a human resource. Okay, it's always a human resource. And you could see that there are specific rights and privileges are given to each Indian citizen. And the commencement date, I have already talked about that. Then there are two things. The two documents mainly talk about the citizenship. One is the second part of the constitution, that is the Article 5 to Article 11 of the Indian Constitution talks about the second part. And another important document is an act made by the parliament, that is Citizenship Act 1955. Later, there were many amendments for this particular act. Now, you should also understand about who is an illegal migrant. So illegal migrant is a foreigner who enters the country without a valid travel document like passport or visa, or sometimes they enter the country with these valid documents and but stays beyond the permitted time period. So that also be considered as an illegal migrant. And there are many other things that you need to learn before actually understanding citizenship, like who's an ambassador, what is a consulate, what is an embassy, what is a high commission, and what is a FRRO, then inner line permit. Okay, then so many things you need to understand. All those things are there in the IPM IAS app. Okay, as detailed videos, you will be able to understand it from that. But here I'm just going through the revision part only. So I'm just going through important things. So these are some of the rights and privileges for Indian citizens. You can just pause for a moment and then understand about it. Rights and privileges of Indian citizens. Now, the rights and privileges for Indian citizens and foreigners, okay, except enemy aliens. Enemy aliens are enemy countries, okay. Then, what is Article 5? Article 5 of the Constitution talks about citizenship at the commencement of the Constitution, okay. So, basically here, the citizenship is decided based on the domicile, okay, based on domicile, where they are living. So, who was born in the territory of India, or either of whose parents were born in the territory of India, or who has been ordinarily resident in Indian territory for not less than 5 years. Immediately preceding such commencement shall be a citizen of India. Okay, so in a particular case, D.P. Joshi versus State of Madhya Pradesh, it was actually decided that there is only one domicile in the country, that is the domicile of India. Okay, so Article 5 talks about citizenship at the commencement of the Constitution, talks about domicile, citizenship by domicile, where they are actually living. And there are conditions for that. Either that person should be born in this India, or either of their parents should be born in this territory, or they have been an ordinary resident for India prior to 5 years. Okay, not prior to the commencement of the Constitution. Then Article 6 of the Constitution talks about the rights of citizenship of certain persons who have migrated to India from Pakistan. Now this is very important. Okay, basically when partition was going on, there were people who were taking two stands. Okay, one may be going with the Indian Union, and one may be going with the Pakistan. Okay, that is their wish, whether to join India or not. That is their wish. And what happened was, before it was British India, so Pakistan was also part of India. But when the partition happened, people who are living in Pakistan, they would like to come back to India. So what will happen to them? Okay, what are their rights? That is what is mentioned here: rights of citizenship of certain persons who have migrated to India from Pakistan. That is clearly noted here. So here you can see that, and they have introduced a particular system called permit system. It was on 1948. Permit system was introduced in both states so that people who wanted to go. Now, before that, there were some problems. There were riots and all those problems were going on. So at a certain point, they have stopped this. This permit was stopped, but then they have actually reopened it. Those who want to go, no, they can actually go and come. So for that option was opened in 19th July 1948. Permit system was introduced. So basically, if somebody is asking you, Article 6 is mainly talking about people who have migrated to India from Pakistan. Okay. Now, you should also understand that what is the citizenship status of people who have migrated to Pakistan and then came back to India. Very important. Okay, because during the panic situation, people might have taken a wrong decision to go to Pakistan, but then later they have realized that no, this is not the right place for me. I have to go back to India. So now what is their status? It is actually discussed in Article 7. That is rights of citizenship of certain migrants to Pakistan. Okay, then came back to India. Those who went to Pakistan, we don't need to worry about it. Okay, just we can leave them. We don't need to worry because they have their own citizenship for the Pakistani people. But here, people who have migrated to Pakistan and then later came back to India, we have to consider them. No? So that consideration is actually based on certain criteria, and that criteria is actually listed here. You can read it and understand. Okay. So pause for a moment and you can read it and understand. Then Article 8 is the rights of citizenship of certain persons of Indian origin residing outside India. So there is something called as person of Indian origin. Okay, so person of Indian origin means if they are living in this country, then we will not be calling them as person of Indian origin, right? But they are actually going outside. They are actually living outside. They may be a foreigner. They may be a foreign national. So for that, we have to give certain options. So any person who or either of whose parents or any of whose grandparents was born in India as defined in Government of India Act 1935 can be considered as a person of Indian origin. So their rights also need to be their citizenship rights also need to be taken care of. And that is discussed in Article 8 of the Indian Constitution. Article 8 of the Indian Constitution. Now, Article 9 of the Indian Constitution, it's actually talking about persons voluntarily acquiring the citizenship of a foreign state. They are not citizens of India. Okay. We may be an Indian citizen, but if they are acquiring the citizenship of a foreign state, then at that moment itself, they are actually not becoming a part of the Indian citizenship process. Okay, so that is Article 9. Then Article 10 mainly talk about the continuance of the rights of citizenship. Basically, whatever possible from the Constituent Assembly side, they were able to frame and include it in the citizenship part. That is part 2 of the Indian Constitution. But what will happen to the people who are coming in the later stages of this country? Okay, you can see that after 1950, what is going to happen in the citizenship? If a change need to be happen, who will actually make the changes? So that need to be taken care of, no? So that is actually coming in Article 10, that is continuance of the rights of citizenship. Every person who is deemed to be a citizen of India shall continue to be such citizen subject to the provisions of any law made by the Parliament. So now who is having the authority to make laws? The Parliament. The Parliament is supreme in the case of citizenship process. The Parliament enacted the Citizenship Act in 1955, namely renunciation, termination, and deprivation that prescribes 3 ways of losing citizenship. So, based on this particular idea only, the Parliament has come up with something called as the Citizenship Act in 1955. Okay, so after 1950, whatever things related to citizenship will be decided by the Parliament only. Now, Article 11 of the Indian Constitution, you need to understand that. Article 11 says that Parliament has the authority to regulate the right of citizenship by law. So nobody else, state cannot regulate that, state legislature cannot regulate that, no individual body can regulate that, only the Parliament has the authority to do that. Article 11 of the Indian Constitution empowers Parliament as the sole authority to legislate on regulating citizenship of individuals. Sole authority. So nobody can claim that right. Is the Parliament has the sole authority to make laws on Indian citizenship. So I hope that part is clear. Article 5 to Article 11 of Indian Constitution mainly deal with the citizenship. Okay, citizenship of India. Now coming to Citizenship Act 1955, very important one. Citizenship Act 1955 and its amendments deal with the acquisition and termination of citizenship after the commencement of the Constitution of India. So till the commencement of the Constitution, everything was detailed. The status of the citizenship, how it can be acquired, everything was actually detailed in the Constitution itself. Now after that, everything was actually detailed in the Citizenship Act 1955. How you can actually acquire the citizenship and how you can actually lose the citizenship. And based on the changes happening to our society, based on the need, there were a lot of amendments happened to the Citizenship Act also. Around 6 times it was actually amended, and the latest one being in 2019. And it includes how acquisition of citizenship, and it also includes how the termination of citizenship. These are the acquisition, the eligibility acquisition basis. One is citizenship by birth, citizenship by descent, citizenship by registration, citizenship by naturalization, and citizenship by incorporation of territory. Okay, by birth you can get, by descent you can actually get. So there are actually conditions for each of these cases. And then by registration you can become a part of India. By naturalization we can become a part of India. So here, if an American citizen wants to become an Indian citizen, then he has to undergo the naturalization process. Okay, you need to understand that. Then incorporation of territory. For example, Goa was not a part of India. Later it was actually acquired and incorporated into our territory. So whoever were there in the Goa, they automatically become Indian citizens. That is incorporation of territory. That's about the citizenship part, and there were a lot more things you need to understand about citizenship. The recent Amendment Act 2019, you need to understand about it. Then many things related to citizenship you have to have an idea, and everything is actually listed in the IPM IAS applications website. It is there in our courses. Okay, any of the courses you purchase, you will get this information. Even if you want to get this information, you can become a part of the IAS Dream Experience Program. It's only 3,000 rupees for 3 months. You can get all these details in Indian Polity. Now coming to the part 3 of the Indian Constitution, mainly deal with the fundamental rights. Okay, the rights that we have, fundamental rights. Now, part 3 of the Indian Constitution deals with it, and it is often called as the Magna Carta of the Indian Constitution, and it also has inspired from the Bill of Rights of the US Constitution. And you could see that the rights which are mentioned in the fundamental rights are justiciable in nature, which means if somebody is actually violating these laws, these rights, you can definitely approach the court. You can directly approach High Court and Supreme Court. Now, what are the salient features of this fundamental right? It promotes ideals of political democracy. These are certain qualified privileges and not absolute in nature. Very important. The rights that we have, these are not absolute. You cannot enjoy it in its full potential. You won't be able to do that. There are certain regulations will be there, and they are self-executory in nature. They are justiciable in a court of law, and it's a part of the basic structure of the Indian Constitution. Okay, all these things are salient features of the fundamental rights, and they are not absolute but qualified, and these rights are actually available against the arbitrary action of the state. So whenever people coming to power, you could see that they can actually become arbitrary in nature. Okay, whatever comes to their mind, whatever they decide should become the law. So these kinds of mindset can come. So in order to curtail that, in order to fight against such tendencies, we have the fundamental rights. They are guaranteed and defended by the Supreme Court. So somebody is asking you who's the defender and the defender of the Indian fundamental rights, you can say that it's the Supreme Court. Okay. Then if they are not sacrosanct or permanent, Parliament can amend fundamental rights, but without making any changes to the basic structure. Okay. And one more important point you need to understand that their application to members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous services can be restricted or abrogated by the Parliament as per Article 33. Very important. Basically, like what the ordinary people are enjoying as fundamental rights, the people of military or people who are becoming a part of the intelligence forces, raw, etc., they won't be having this kind of a fundamental right. They won't be able to enjoy like that because it is a part of that process. Basically, they are working for the security of this nation, and they are the ones who are actually ensuring that. So in order to ensure that, they need to have discipline in that force, and in order to ensure that discipline, they are actually doing this. Basically, they are restricting certain fundamental rights and its application in these forces. Now, what is it actually starts from Article 12, Article 12 of the Indian Constitution to Article 35 of the Indian Constitution deals with the fundamental rights. Article 12 to Article 35. Article 12 mainly defines what is a state. Okay, state means who all are included in that. It can be government of India, it can be government of a particular state, and the local authorities. All those things. What is a state is clearly defined by that, because you are dealing with fundamental rights against the state. Okay, you are actually trying to question the actions of the state. So whenever the state is coming up with a new law, the new policy, then first you need to understand whether it came from the authentic state. In definition, if it is actually belonging to a state, then only you can actually go against that. Okay, so for that purpose only, they are clearly giving definition for state in part 3, that is Article 12. Then please go through it, and I know you might have gone through it in detail. Now, Article 13 talks about the law. So what is that law? Okay, who can actually frame the law? Now, Article 13 of the Indian Constitution declares that all laws that are inconsistent with or derogation of any of the fundamental rights shall be void. Provides a doctrine of judicial review. The idea of judicial review, that means the Supreme Court can interfere into the lawmaking process. So once a law is actually made, then Supreme Court can actually review that. If it is violating the rights, if it is violating the Indian Constitution or the fundamental rights, then Supreme Court can declare it as null and void. Okay, all those points were actually discussed in Article 13. And it also discussed about the law. What is a law? Okay, what is an act? All those points are actually covered here. Now, the first article, okay, that is a right to equality. We are having 6 fundamental rights: right to equality, right to freedom, right against exploitation, religious rights, cultural and educational rights, and right to constitutional remedies. We have 6 fundamental rights, and in all these fundamental rights, you will be able to see the detailing. Okay, Article 14 to Article 18 of the Indian Constitution deal with the right to equality. So one is equality before law. Everybody is before the eyes of law, they are all equal. So that is the idea of this one. And there should not be any discrimination based on only of religion, caste, race, sex, place of birth, or any of them. So only on these aspects, there should not be any kind of discrimination. So that is equality before law. And there is a concept called the rule of law. So it was actually propounded by A.V. Dicey. Okay, that also talks about this. Law is always supreme. Okay, everybody is equal before the eyes of law. Nobody is above the law. Okay. Now, equality before law and equal protection of law. So its idea. It's one is negative in nature, equality before law, equal protection of law, positive in nature. It's adopted from Britain, adopted from USA. Privileges are absent. In order to accommodate diversity, they have come up with that. And equality before law, it's like a conservative approach, and equal protection of law, it's a progressive. Okay, so this is basically 2 different ideals, and both are included in our equality. The rule of law, like I've already told you, it is to ensure that our absence of arbitrary power is there. So, absence of arbitrary power, they take laws, or they actually make laws, or they take decisions without any valid legal support. Okay, like a dictator is taking a decision, how an autocrat is taking a decision. So whatever comes to their mind will become a law. So that should not happen. Everything should be functioned based on the law written in the country. So that is rule of law. Now, there are certain exceptions also, like there are certain immunities enjoyed by president and governor. Okay, so all those aspects are actually coming in the later stages based on Article 361. So there are certain exceptions to equality. Like when you're actually saying that everybody is equal before the eyes of law, then which means you and the president also should be equal before the eyes of law. No, but on certain cases, you could see that it is not like that. There are certain immunity enjoyed by the president, governor, and certain other important positions. Okay, so that is what is listed there. Then the second one, that is, the, Article 15 talks about the prohibition of discrimination on certain grounds. Okay, the prohibition of discrimination on the grounds only of, this means only means what? Only on these aspects there should not be any kind of discrimination, but it can be some kind of discrimination on other aspects. Okay, this only on religion, caste, race, sex, place of birth, or any of them, there should not be any kind of discrimination. So, like the prohibits the state to discriminate citizens at shops, restaurants, hotels, places of public entertainment maintained partly or wholly out of the state funds on the grounds only of religion, caste, race, sex, place of birth, or any of them. So, basically, the public areas, public wells, public tanks, public washrooms, road, but for using all these things, they should not come up with any kind of restriction or discrimination based only on these points. Okay, so that is what is listed here in Article 15. In 1927, Dr. Bhimrao Ambedkar led a procession of untouchables from Mahat to Chowda Tank, a public tank from where untouchables were prohibited from drawing water. So they were prohibited from drawing water based on the social norms during that time, like the caste system and all. But already the government or the judiciary has approved that they can actually take water. So that's the, but they were also hesitant to take water from there. So that's the reason why Ambedkar has done this procession. They did this procession to Chowda Tank. Okay. So basically, these are public properties, and public property should have access to public. Everybody should have equal access to the public property, and there should not be any kind of discrimination. Not any kind, only on these kinds: religion, caste, race, sex, place of birth, or any of them. Then Article 16 talks about equality of opportunity in public employment. So in public employment, like you all are going to write the civil service examination conducted by UPSC. So how they are conducting? They are not actually conducting examination for taking their favorites. They are not allowed to do favoritism here. No nepotism in this area. Only on merit they will be appointed. Like based on your marks, you will be selected for the mains examination. Based on your marks in mains, you will be selected for interview. And based on the interview marks and the mains mark, you will be posted in a rank, or you will get a rank and you will be posted in a particular service. So this is what is happening. So it's basically, it is genuine. It is meritorious. It's based on merit, right? And that equality of opportunity. So anybody can actually apply this. Anybody can become a part of this examination. So every public employment should be based on this equality of opportunity. All should have equal access or equal opportunity to avail the public employment. Now, Article 17 deals with abolition of untouchability. Untouchability was an offense punishable by law. Okay, it is a derogatory practice existed in the country, and the Parliament enacted the Protection of Civil Rights Act 1955. It criminalized the offense prescribing imprisonment up to 6 months or by fine up to 500 or both. A person convicted of the offense of untouchability is disqualified for election to the Parliament or state legislature. Okay, so untouchability is when if it is actually going on in the society, which means inequality is prevailing in the society. So in order to avoid that, in order to abolish that, we have come up with this particular article, abolition of untouchability. Then comes we are talking about the Untouchability Act 1955, the Protection of Civil Rights Act 1976. Okay, these are some of the provisions associated with that. Prevent any individual from entering any place or public worship or worshipping therein, places of public entertainment, institutions established for public benefit, etc., based on untouchability. Okay, they should not be doing that. And if somebody is actually preaching untouchability directly or indirectly, they will get punishment. If somebody is actually justifying untouchability on traditional, religious, or philosophical or other grounds, they will get punished. And if somebody is insulting an individual, including refusal to sell goods or render services only on grounds of untouchability, definitely that person is going to be punished based on the Untouchability Offences Act and Protection of Civil Rights Act 1976. Then Article 18, it actually talks about abolition of titles. Okay, so except the academic and the military titles, nobody should be having the authority to keep the titles. Okay, very, very important, like Raja, Raj Bahadur, etc. Certain titles enjoyed by the people here in India. but now it is not there, because the moment we are actually giving that authority to someone to keep that title, no, then the inequality prevails. Okay, then the discrimination happens. So that is the reason why the titles are actually abolished. It prohibits the state to confer hereditary titles of nobility only to its citizens except military or academic. So only we have to keep the military or academic titles. Now coming to right to freedom. Okay, right to freedom. So Article 14 to Article 18 of the Constitution deals with the right to equality. Now we are going to discuss about the right to freedom. And these rights are available only to citizens and the shareholders of the company. They're not available to foreigners or legal persons like companies or corporations. Then the constitutional remedies against the right to freedom is available against the actions of the state only. The responsibility of the state to ensure right to freedom of citizens, and the right to freedom under article can only suspended during operation of national emergency, declared on the ground of war or external aggression, and not on the ground of armed internal rebellion. So when we are talking about freedom, we may think that, okay, we are enjoying our freedom to any level, to any extent we can enjoy the freedom. No, that is not the case. Actually, there are certain restrictions of freedom, especially on speech and expression. There are certain restrictions. And you could see that the first amendment bill, 1951, listed out grounds for restriction on freedom of speech and expression. And these are in respect of the sovereignty and integrity of the country. Okay, one is sovereignty and integrity of the state, the security of the state, friendly relations with the foreign states, public order, decency or morality, contempt of court, defamation, incitement to offense. You could see that, like, if our freedom is affecting any of these things, any of the things which are actually listed there, then definitely then it can be restricted. Our freedom can be restricted. Article 19 talks about the six rights to its citizens, basically six freedom. One is right to freedom of speech and expression, right to assemble peacefully without arms. Okay, right to assemble peacefully without arms. You have the right to do that. Then right to form associations or unions or cooperative societies. You can form associations, you can form unions, or you can form cooperative societies. Right to move freely throughout the territory of India. Okay, freely you can actually travel through the territory of our country. Right to reside and settle in any part of the territory of India. Right to reside and settle in any part of the territory of India. Right to practice any profession or to carry on any occupation, trade or business. Right to practice any profession or to carry on any trade or business. Very important. So these are certain rights enshrined in our constitution as per Article 19, but these rights can be restricted. Okay, based on the certain ground, based on certain criteria, these rights can be restricted. That is very, very important. But before we were having the right to property also, but it was actually deleted by the 44th Constitutional Amendment Act of 1978. Now, each of these things need to be explained in detail, and I hope you know about it. That is the reason why I'm not going into the detail. What do you mean by speech and expression? What are the things included in that? Okay, on what all circumstances your speech and expression will be curtailed. All those things are actually listed properly there, but you need to understand about it. Since Article 19 talks about these six rights, six freedoms. Okay, Article 19. Then Article 20 talks about the protection in respect of conviction for offenses. Conviction for offenses. When we are talking about the conviction of a person, then certain protection is actually there. One is no ex post facto law. Ex post facto law means no one can be convicted for an act that was not an offense at the time of its commission. Okay, so you know about it, right? So that is no ex post facto law. That's a protection. No double jeopardy for the same offense. Nobody can be prosecuted and punished for the same offense more than one time. No self-incrimination. No one can be forced to give witness against his or her own self. So the conviction, the confession, okay, the confession that the people are actually doing, so if you are actually confessing something, then it is the responsibility of the police to find out evidences that supports that confession. Okay, so no self-incrimination, no double jeopardy, and no ex post facto law. These are certain protections given in respect of conviction for offenses. Article 20. Then this is no ex post facto. imposes punishment retrospectively. Okay, limitation is imposed on criminal laws, not on civil laws or tax laws. Okay, so these are, you can just pause and you can just read about it. Now, double jeopardy means this one available only in proceedings before court of law and or a judicial tribunal, not available for proceedings before departmental or administrative authorities. Okay, and as they are not judicial in, very important. Then no self-incrimination, so extends to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material objects. Okay, compulsion to give thumb impression, specimen signature, blood specimens, compulsory exhibition of the body. It extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal in nature. Very important. Okay, so 3 important protections are actually given based on Article 20. Article 21. Okay, Article 21, it's talking about the protection of life and personal liberty. Protection of life and personal liberty. Very important aspect, right? So no person shall be deprived of his life or personal liberty except according to procedure established by law. Okay, here you should also understand about the procedure established by law. Okay, the right is available to every person, citizens and foreigners alike. The Supreme Court of India says that the heart of the fundamental rights, it is the heart of the fundamental rights, and there were several landmark judgments based on this particular one. And you could see that here they are only saying that protection of life and personal liberty, but what is its in-depth meaning? Okay, what all things can be interpreted based on this? Everything was actually interpreted through various cases. You could see that the Supreme Court has come up with a list of things, the list of freedom, list of rights associated with this one. Okay. Maneka Gandhi versus Union of India case 1978 is an example for this. Then these are some of the interpretations you could see. Okay. You can just pause for a moment and understand it, read about it. So all, I mean, certain rights which are actually connected with the right to life and personal liberty. So some examples are like right to decent environment, including pollution-free water, air, and protection against hazardous industries. Very important. So pollution-free water, that is also our right. Right to sleep is also included here. Right to health is included here. Right to fair trial is included here. Right to travel abroad is included here. Right against handcuffing is included here. Then right to information is included here. Right to reputation is included here. Then right against bar fetters is included here. Then right to appropriate life insurance policy is included here. Right to opportunity, right to sustainable development. So, which means these are certain things which we don't even think about when we are actually looking at right to life. But all these things were interpreted in the Supreme Court and they have given clear verdicts based on this. So that all these things can be part of right to life and personal liberty as per Article 21. Then another one is the right to education, which is actually enshrined in Article 21A. So the moment you are actually seeing that 21A, you can understand that it is based on an amendment. Basically, it is based on an amendment. The 86th Constitutional Amendment 2002 inserted Article 21A to the Indian Constitution, which states the state shall provide free and compulsory education to children of 6 to 14 years in such manner as the state may by law determine. So it is the right of the people to get that and to provide opportunities for education to his child or ward between age of 6 and 14 years. This is the duty which was actually added in 86th Constitutional Amendment Act 2002, and it is the duty of the parents to ensure that. It's an Act of Parliament, RTE. It's an Act of Parliament enacted in August 4, 2009, which describes the modalities of the importance of free and compulsory education for children between 6 and 12 in India under Article 21A of the Indian Constitution. Okay. Then Article 22 deals with protection against arrest and detention. So in Article 20, we have seen that protection related to conviction for certain offenses. But here we are talking about regarding arrest and detention, there are certain protection. Okay, let us see that. Article 22 of the Indian Constitution guarantees certain fundamental rights for individuals against arrest or detention, and the rights available under protection against arrest and detention are right to be informed on the grounds of arrest. Okay, when you're actually going to arrest somebody, that person should know about why they are getting arrested. Then right to consultations for legal defense. So finding out an advocate for them, or getting the legal aid is another important right for them. Right to be produced before the magistrate within 24 hours. So the from the moment you are taken into custody, within the 24 hours you should be produced before the magistrate. Right to be released after 24 hours unless the magistrate authorizes further detention. If the magistrate is not authorizing further detention, then it is a duty of um, the, the police to release them. Okay, because they are not getting the approval for further detention. Okay, the safeguards are not available for an enemy alien or a person arrested or detained under the preventive detention law. So this is not applicable for people who are arrested based on preventive detention law. It is applicable for others. And also enemy alien, it is not applicable. Then there are two kinds of detention. You can see that one is punitive detention, another one is preventive detention. So punitive detention means it's awarded as a punishment to an individual convicted of an offense by a court of law after due process of legal trial. So after the trial, if they are actually convicted and then going for a detention, that is punitive punishment. So coming to preventive detention, it refers to detainment of an individual without trial or conviction by a court. So it is actually happening without the trial or conviction by a court. It is imprisonment beforehand to prevent possible commitment of crime. So it is to prevent a crime to happen. But the other punitive detention is crime already happened and it is an after effect of that. It's a punishment given for that. So these are certain preventive detention laws enacted by the Parliament of India. You can just pause for a moment and you can just read about it. Preventive detention. Now coming to right against exploitation. Article 23 and Article 24 of the Indian Constitution deal with right against exploitation. What is this? So one is the prohibition of traffic in human beings and forced labor. So it is mainly related with the human trafficking and forced labor. Very important to understand this. Then it is like the right is available to both citizens and non-citizens, protects the individuals against state and private individuals traffic in human beings. Basically, what is this trafficking means? Selling and buying of men, women, and children like goods. Then immoral traffic in women and children, including prostitution. The system of devadasis, slavery, all these things are actually abolished based on this one. Okay, prohibited based on this particular article, Article 23 of the Indian Constitution. The Parliament has enacted Immoral Traffic Prevention Act in 1956. So that is Article 23. Like these are some other things like term beggar, compulsory work without remuneration, forced labor. We have seen that, no? Historically, local zamindars did this to their tenants. Compulsory work without any remuneration, without any payment, they are actually working. And it prohibits bonded labor also. Bonded labor is when a person is forced to offer services out of a loan, debt, or which that cannot be paid. Forced labor is compelling a person to work against his will. All these things are actually prohibited in our country. And certain laws related to that are Bonded Labor System Abolition Act 1976, Minimum Wages Act 1948, Labor Contract Act 1970, the Equal Remuneration Act 1976. In all these areas, you could see that there are mentions or references related to this. Then prohibition of traffic in human beings, we have seen that. Then prohibition of employment of children in factories. Okay, Article 24. So Article 24 of the Indian Constitution prohibits the employment of children aged to below 14 years in factories, mines, and other hazardous occupations. It doesn't prohibit their employment in any other harmless or innocent work, but later we could see that later through many laws, many judgments, we could see that this was also prohibited. Okay, and certain acts which actually mentions this were the Child Labor Prohibition Act 1986, the Factories Act 1948, the Mines Act 1952, BD and Cigar Workers Act 1966 are all prohibit the employment of children in factories and hazardous places as a cognizable offense punishable under law, as a cognizable offense. In 1996, the Supreme Court established as per the rule of the Supreme Court, they established the Child Labor Rehabilitation Welfare Fund of offending employers should deposit a fine of 20,000 rupees for each child they have employed in his initiative or his company. Okay, so that you need to understand. So this, you can read more about it. Pause for a moment and you can just read more about it. It's also regarding that. Then right to freedom of religion, that is the next article. Okay, so we have seen three important rights. One is right to equality, right to freedom, right against exploitation. Now right to freedom of religion, article 25 to 28 of the Indian Constitution deals with that. Now what is it all about? One thing is like freedom of conscience and free profession, practice and propagation of religion. Very important. Okay, freedom of conscience, free profession, propagation and practice. What do you mean by freedom of conscience? The inner freedom of an individual to mold his relation with God in whatever way he desires. That is freedom of conscience. That's something happening inside one person. Right to profess means declaration of one's religious beliefs and faith openly and freely. You can profess, you can actually talk about your religion. You can say that, okay, I belong to this religion. Right to practice, performance of religious worship, rituals, ceremonies, and exhibition of beliefs and ideas. Okay, so basically you are practicing it, you are actually doing certain things related to the religion. Then right to propagate, that is transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion to others. But here what you need to understand is forcible conversions impinge on the freedom of conscience guaranteed to all persons alike. Okay, so these are the points related with the right to freedom of religion, freedom of conscience, right to profess, right to practice, and right to propagate. Then this article covers religious beliefs as well as religious practices. Okay, that also you need to understand. And there are also they are also subject to restrictions based on public order, morality, health, etc. If any of these activities are going against the public order, morality, or health, then there will be restrictions on that. Then Article 26 of the Constitution talks about freedom to manage religious affairs subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right. Okay, so they managing their affairs. What does this affairs means? To establish and maintain institutions for religious and charitable purposes. Okay, maintaining institutions. You know that every religious institution in this country have their own institutions, their own charitable organizations. They can do that. So it's based on Article 26. To manage its own affairs in its matters of religion. To own and acquire movable and immovable property. To administer such property in accordance with the law. So that is very important because everything, whatever they are doing, it should be in accordance with the law. So that is Article 26. Okay. So this is more about the Article 26. You can pause for a moment and read about it. Then Article 27. Article 27 means freedom as to payment of taxes for promotion of any particular religion. That means no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. So freedom from taxation for religious promotion. You don't need to pay tax for religious promotion. That is what you need to understand. And state should not spend for promoting or maintaining any particular religion. That is also very, very important. Then 28. This provides that no religious instruction shall be provided in state-run educational institutions. Very important. Okay, in state-run education institutions, no religious instruction, because state-run means what? It is actually functioning based on the public fund. So public means what? They belong to different religions. So using their fund, they should not be promoting one particular religion. That is what it indicates. Because we are actually considering all religions equally. So there should not be any kind of religious instruction in the state-run educational institution. So there are some other things associated with this particular article. Then what are the 4 types of institutions under Article 28? That is also given here. Institutions wholly maintained by the state, institution administered by the state but established under any endowment or trust. The institutions recognized by the state and institutions receiving aid from the state. So various institutions, various types of institutions. Now coming to cultural and educational rights, which is actually covered in Article 28 and 30 of the Indian Constitution. Article 28 and 30 of the Indian Constitution. One, protection of interest of minorities. Very important. Protection of interest of minorities. Article 29 of the Indian Constitution guarantees certain fundamental rights of citizens belonging to cultural and linguistic minorities. So, what is this minority? This minority is actually defined in terms of two things. One is cultural aspects, and another one is linguistic aspects. Okay. Then protect and promote distinctive heritage of citizens belonging to linguistic and cultural minorities. Prohibits discrimination against individuals for admissions to any education institution maintained partly or wholly out of state funds on grounds only of religion, race, caste, or language. So these are all actually included in Article 29 of the Constitution. And basically, like, we have a majority and minority in every country. So the rights of the minorities should also be protected. That is the sole reason. And when you're talking about the rights of the minorities, it also talks about the rights of the majority also. Protection of interests of religious minorities as well as linguistic minorities. The section of citizens in the Constitution denotes rights of minorities as well as majority. That's very important. Okay. And what is Article 30? Article 30 of the Indian Constitution guarantees certain fundamental rights to the citizens. Okay, certain fundamental rights of citizens belonging to cultural and linguistic minorities. Protect the rights of all religious and linguistic minorities to establish and manage education institutions. Okay, religious and linguistic minorities to establish and manage education institutions. Prohibits discrimination by state in dispersal of funds to such education institutions. There should not be any discrimination when they are actually dispersing funds for the educational aspects. Okay, then three types of minority education institutions. One, institutions that seek recognition as well as aid from the state. Then institutions that seek only recognition from the state, not the aid. Then institutions that neither seek recognition nor aid from the state. These are the three types of minority educational institutions. Then coming to constitutional remedies, right to constitutional remedies, the last fundamental right. So the right to constitutional remedies mainly discuss about the guarantee that is given by the Indian Constitution to the citizens to approach the court of law and seek enforcement or protection against infringement upon their fundamental rights. So if anybody is actually infringing on your fundamental rights, if they are actually violating your fundamental rights, you can definitely approach the court. That is what is listed or discussed in this particular. And how they are actually reinstating that fundamental right. The writs are issued by the Supreme Court and the state high courts to enforce the fundamental rights under the right to constitutional writs. There are 5 types of writs: habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Habeas corpus talks about the writ of prerogative in nature, and it is used to remedy against unlawful detention of any individual, any prosecuting agency. Habeas corpus is often issued against public authorities and private individuals. So, to have the body, that is the meaning of the word habeas corpus. If you are unlawful detention, so the court will say that, okay, produce that person in the court. That is habeas corpus. And mandamus means it's used to give directions to act or refrain from specific acts of public or statutory in nature, basically giving a command. Then coming to certiorari, that is a writ of preventive and curative in nature. Review the record of proceedings to transfer or quash proceedings against an individual or a legal entity. Basically, to be certified, that is the meaning of the word certiorari. It's often issued against subordinate judicial or quasi-judicial bodies and administrative authorities. Basically, an higher court can actually do this. Okay, they can quash the proceedings against an individual, or they can transfer the proceedings against an individual. Then coming to prohibition. This writ is actually used to prohibit the exercise of extrajudicial powers or act derogatory to natural justice. Basically, if some court or judicial body, the subordinate court, is actually going out of their jurisdiction or trying to perform out of their jurisdiction, then definitely they can actually prohibit that. That is prohibition. Now, quo warranto, the meaning is with what authority? On what authority? That is, there it is used to explain the claimed source of authority to exercise power. with what authority you are actually exercising power. It can be issued against statutory and constitutional authorities and cannot be issued against private individuals. Okay, these are the 5 grids based on Article 32 of the Indian Constitution. Article 33 empowers the Parliament to make laws that would restrict the application of fundamental rights to a specific category of people, including members of the Indian Army intelligence organization. So basically, we all are enjoying fundamental rights, but in certain forces, you could see that it can be restricted, and that restriction is actually coming from the Parliament only, and especially in Indian Army intelligence agencies, etc. So these are the important ones. One is the members of the armed forces, the members of the forces charged with the maintenance of public order. So these are all places where you need to maintain discipline. So in such areas, you will be able to restrict the application of fundamental rights. Then Article 34 talks about providing the restrictions on fundamental rights while martial law is in force in the area within the territory of India. So if martial law is actually in place, then you can see that during that time, your fundamental rights will be suspended. Okay, there will be restrictions for that. Okay, the Parliament is authorized to indemnify or any government servant for restoration of law and order whilst martial law is imposed, even if those actions were violative of fundamental rights. The concept of martial law has been borrowed from British. The term martial law has not been defined in the Constitution. There are no grounds mentioned in the imposition of martial law. Two things very important. Okay, one is not defined properly in the Constitution. Another one is like no grounds are mentioned on at what time it can be imposed. Okay, during the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. However, the Supreme Court held habeas corpus is not suspended when martial law is in force. So now, what is the difference between a martial law and a national emergency? Martial law affects only fundamental rights. National emergency affects the fundamental rights and center-state relations. Martial law suspends the government and ordinary law courts, but in national emergency, they continue to exist. Then martial law imposed to restore law and order. Then national emergency during the time of war, external aggression and armed rebellion. Then it is imposed on specific areas, martial law, but national emergency can be imposed in some or all of the country. And there is no specific provision in the Constitution mentioned about martial law, but there are detailed provisions related to the national emergency in the Indian Constitution. So these are the important aspects related to fundamental rights in the Indian Constitution. So you have to go through it. It's a very, very important area because if you look at the previous year's question papers, you would see that one way or the other, they will ask some questions related to fundamental rights in the Indian Constitution. So I hope you are able to get some idea regarding the Indian Constitution. Okay, it's a very fast manner I'm going, but I hope you are getting that idea. Okay, it's basically a revision only, and in two ways you can actually use it. For one set of people who have already studied about Indian polity, and when you are going through a revision, you can use it. And another set of people who are beginners in this field, then you can actually understand about the overview of the Constitution when you are going through it. Okay, in two ways you can actually use it. So like I already told you, like if you are interested about knowing about the courses, you can definitely check the link below. You have all the courses available there. And one more thing is like the IAS Dream Experience Program will be helpful for students who are writing the examination this year because it contains everything. And if you have access for 3 months, no, you can definitely get that access for 3 months. In 3,000 rupees, you will get everything, every aspect. So you can go for a revision easily. You will be able to understand the concepts really well, and which will be helpful for your examination.